Can everyone hear me? Today, I'm the managing partner at Hudson McKenzie. My name is Rahul Batra, and I'm joined by Ling, Yi, and Josie Day from Thornton, UK LLP, covering tax aspects for Hong Kong nationals looking to move to the UK, and Brandon Meyer, who's the managing partner at Meyer Law Group, to discuss US immigration options for Hong Kong nationals. So I would like to start with the first slide, which is for UK immigration options and the new BNO visa, which has been announced by the UK government recently. And I'm sure a lot of you would like to find out what the details are. So on 22nd of July, the UK government published details of this new immigration route, which starts from 1st of January 2021. And there are certain conditions which have to be satisfied in order to be eligible for this visa. And one of the conditions is that you must have a BNO status, which means you either have a BNO passport, which is the British National Overseas Passport, or you have a status, even if you don't have a BNO passport. You should usually reside in Hong Kong and should be able to financially support and accommodate yourselves when you come to the UK. And you have to have a commitment to learn English language, and you also need to obtain a TB test from an approved clinic. The visa duration is for 30 months, and you can extend the visa for another 30 months, or you could simply apply for a 5-year visa at the very outset. And this visa will let you work in the UK and study in the UK, but you cannot benefit from public funds, which is the norm. And the good thing about this visa is that after 5 years, you can apply for indefinite leave to remain, which we call ILR in legal jargon. And after 6 years, you can qualify for British citizenship as long as you meet the requirements. A lot of people would like to enter the UK prior to Jan 2021, and the government is very open to such people. You could either enter as a visitor for up to 6 months, or if you just turn up at the airport, they may not let you go back. They may just give you leave outside the immigration rules for up to 6 months. And the good thing is that you're allowed to switch into a Hong Kong BNO visa from that visit status once the route opens on 1st of Jan 2021. I've had a lot of questions from Hong Kong nationals who have children born after 1997 and who are over 18 years of age, who do not qualify as dependents under the UK immigration rules. What the government has announced is that they are willing to apply discretion, and as long as you can show compelling and compassionate circumstances for children born in Hong Kong who after 1997 and who are over 18 years of age. So nothing to worry there. We could potentially help them come over as well as a family unit. There are alternate options for people who don't qualify for the BNO status, and I'm going to cover them very briefly. If you need further details, you can always contact me later. My contact details will be at the end of the slides. The first option is the investor option, which is you need to invest at least £2 million in the UK. You get indefinite leave to remain after 5 years and citizenship after 6 years. The conditions which have to be met are that you must have 2 million of your money, which is disposable in the UK and held in a regulated financial institution. It could be held anywhere in the world. It doesn't have to be held in Hong Kong. You should be over 18 years of age. You have to prove that the money belongs to you, your spouse, unmarried or same-sex partner. You must have opened a UK bank account. And one of the conditions is that you must invest the money in UK share capital or loan capital in active UK companies. The benefit of this visa is that you get exemption from English language and maintenance requirements, which can be quite cumbersome at times for people. You do not need to have any job offer under this category. And the visa duration is for 3 years, can be extended by a further 2 years. And as I said earlier, you can apply for citizenship and ILR after a set period of time. Then you have the company-sponsored visa, which is the Tier 2 General Visa and the Tier 2 ICT Visa. As I said, they're company-sponsored, so you cannot apply on your own. The company has to apply for a COS for you, which is the Certificate of Sponsorship. There are certain requirements to be met for both kind of visas. And one of the requirements for Tier 2 general visa is that the job must be at NBQ level 6, which is soon to be dropped to NBQ level 3 from 1st of Jan 2021 onwards. The minimum salary is £30,000 or in line with the SOC codes. There's a restricted quota application to be done at the moment, which will be removed from 1st of Jan 2021. The advertisement requirement gets dropped from 1st Jan 2021 as well. You still have to meet the English language and maintenance requirements. For ICT visa, it's for people who are temporary transferring to the UK and who are employees of overseas companies based abroad. The maximum allowed stay is 5 years or 9 years if the salary is over £120,000. They must meet the maintenance requirement. And one of the conditions for such visa is that you must have worked for the overseas company for at least 12 months. The drawback of this visa is it does not lead to ILR or British citizenship. So you must return to your country after you finish your visa. Then we have the Tier 4 visa, which is your student visa. The requirements for this visa are you must be over 16 years or above. You must have an unconditional offer of place on study with a licensed Tier 4 sponsor. You must be able to speak, write, and understand English. You must have enough money to support and pay for the course, and the money will vary depending on your circumstances. So it's not the same set of money for everyone. And you need to meet the following requirements to do a course, which is a full-time leading to a qualification that is level 6 or at level 7, which is the PhD, or you are learning, or you're attending a course which is at least 15 hours per week leading to a qualification, which is a level 3, which is the bachelor's course. And then you have a foundation program or a postgraduate doctor or dentist or an English language program at level B2 or above. We then have the Tier 5 visa, which are the temporary visas for overseas nationals. One of the relevant option is the Tier 5 government authorized exchange. It is designed for short-term work experience or training for overseas nationals who can come to the UK and work for up to 2 years. The COS has to be issued by an overarching body, which we can assist with. The company doesn't have to issue their own COS. You must be paid at least national minimum UK wage, and dependent family members can join and work in the UK. Then we have the Tier 5 Youth Mobility Scheme, which is pretty straightforward. It is for Hong Kong nationals between the age of 18 to 30 years, have some savings, and they want to come and live in the UK for up to 2 years. This was the old Working Holiday Maker scheme many, many years ago. So that has been replaced by the Tier 5 Youth Mobility Scheme. Then we have the option of a sole representative of an overseas company. It's very popular amongst our clients who are looking to set up a first entity in the UK. It's basically setting up your first branch or a subsidiary and just to test waters in the UK. So no investment is required, which is a big change from the investor visa where you have a big ask of £2 million. Then the other requirement is that you must not have any trading presence in the UK. So it must be your first office in the UK. You must have been employed directly by the parent company overseas and must hold a senior post. And one of the other conditions is that you must not be a majority shareholder in the parent company. And as usual, you have to meet the English language requirement. The visa is granted for 2 years, and then you can extend for the 3 years. And after 5 years, you can apply for ILR and citizenship after 6 years. And dependent family members can join the applicant and can live and work in the UK. Then you've got the startup visa, which replaces the entrepreneur visa, where you had to invest £200,000. The good thing about startup visa is you don't have to invest anything. There's no financial commitment from your side. You must be looking to set up a novel business in the UK, and there's no requirement to have any initial capital investment. You must be at least 18 years old, and as usual, you need to meet the English language and maintenance requirements. One of the main conditions of this visa is that you must have your business plan endorsed by an authorized body, which we can assist with. And as long as they can confirm that your business is scalable and meets certain requirements, they would normally grant you the status to be able to apply for a visa, which you apply from your home country. The visa is granted for 2 years, and unfortunately, you cannot extend this visa. You can switch into a different kind of visa from within the UK, and dependent family members can join the main applicant. Then you've got innovator visa, which is again aimed at those who want to set up or run a business in the UK. The condition for this visa is that you must have at least £50,000 of your own funds to invest in a UK business. And as with the startup visa, you need to have your business idea assessed by an approved endorsing body, which again, we can assist with. You would normally meet the English language and maintenance requirements. And one of the main benefits of this visa is that you can stay in the UK for 3 years and extend for a further 3 years. But then you apply for ILR after 3 years, which is a big change from different categories where you wait for 5 years to apply for ILR. And as with other categories, your dependent family members can join you whilst in the UK. Then we've got the Ancestry Visa, which is for citizens of Commonwealth country where one of the grandparents was born in the UK. The requirements are that the applicant must be a Commonwealth citizen, and they must be able to prove that one of their grandparents were born in the UK, and they must be 17 years or over and be able to plan to work in the UK. They must have enough money without help from public funds. You get the visa for 5 years and apply for ILR after 5 years. And as with other categories, your dependent family members can join you in the UK. I'm going to ask Ling and Josie to step in now to discuss the tax implications for Hong Kong nationals. So over to you, Ling.
Thank you, Rahul. Can everyone hear me and see the slides?
Yep.
Yes.
Okay, thank you. So my name is Ling. I'm from Grand Thornton. I'm joined by Josie, and we'll be talking to you today about pre-arrival tax planning. So the slides are aimed towards individuals relocating to the UK from Hong Kong and China, but a lot of the principles will also apply for anyone coming in from overseas who wants to settle in the UK. So in terms of our team, I'm from London Entrepreneur and Private Client Tax, EPC Tax, and we're specialists in advising high net worth individuals and their families. We also, as the name suggests, we have a specialism advising entrepreneurs. And in terms of who Grant Thornton are, we're the 6th largest firm by fee size in the UK, and we're, I believe, the 5th largest worldwide. As you can see from the slides, we're in most countries, so everything colored purple, we have an office there. We're in over 130 countries, and in China and Hong Kong, we also have offices. So within UK, I'm part of the China British Business Group, which effectively is our China desk. And there's quite a lot of staff who support me in helping to deal with Chinese clients. I myself speak Mandarin, and we also have native speakers in Mandarin and Cantonese as well. So we'll be able to assist and help anyone from China looking to transition over to the UK. I'd like to start by just going through quite a typical case of what we would see. So in terms of this case, we have an individual coming to the UK. They're coming over on the investor visa, similar to what Rahul was speaking about earlier, and they're coming on the 2 million investor visa. They have 10 million total of worldwide assets, which means after the 2 million in the UK, 8 million will be invested overseas, and this generates in the region of 100 to 200,000 of overseas income every year, with some capital gains. Now, a lot of these individuals will also be looking to bring large sums of money into the UK, to bring money in to buy their own personal property. A lot of clients from China and Hong Kong, they also want to buy additional properties for investment purposes, as well as the more sophisticated clients. They would also be looking at investment opportunities in the UK as well. So they want to be able to remit a significant amount of money. So we put our tax hats on. Why is tax planning important here? Well, for the 2 million that they bring into UK on an investor visa, that will be subject to UK tax. However, out of the 8 million that's invested overseas, normally while they're UK resident, they are subject to tax on this amount. But with the right tax planning, we can potentially reduce that to nil. That means out of the 1 to 200,000 of overseas income, which should be taxed every year, and that could be taxed at 45% for income and 28% for gains, we can reduce that potentially to nil with the right planning. So you can already see the benefits of getting tax planning. In terms of bringing funds to the UK, depending on what funds are brought, there may be a tax charge on that, and potentially the highest tax charge would be 45% tax on funds remitted to the UK if they were matched to relevant income. Now, there is a concept called clean capital, and effectively, if you bring clean capital into the UK, you don't need to pay any tax charge on that. And with our tax planning, we can maximize the amount of clean capital available to our clients. So in terms of the next few slides, we'll go through the specifics of our pre-arrival tax planning. We'll look at residence, domicile, and the remittance basis of taxation, which can be a great benefit to our clients. We will also look at the tax impact of bringing funds into the UK and how we can reduce this. And we'll finish off with some tax reliefs and tax efficient structures, which may be a benefit to clients relocating to the UK. At the very end, we'll have a couple of case studies so you can kind of see how everything works and our key message takeaways. For the next few slides, I'll hand over to my colleague, Josie Day.
Thanks, Ling. So I'm just going to expand on some of the points that Ling talked about earlier. And the first thing I'd like to briefly talk about is the concept of residency. So an individual's residency status is very critical to determining their exposure to UK tax. And as a general rule, taxpayers who are resident in the UK are subject to UK tax on their worldwide income and gains. However, if a taxpayer is non-UK resident, they'll only be taxable on their UK source income. And generally speaking, they won't pay capital gains tax, although there are certain exceptions to this rule, which I won't go into now. But as you can see, it's very important that we're able to determine an individual's residency status correctly. And the way that that's done in the UK is through a prescribed set of tests known as a statutory residency test. And it broadly works in 3 stages. So we first look at the automatic overseas tests, and there's 3 of them. And if the individual meets any of these tests, they'll be deemed automatically non-UK resident for the tax year. If none of these tests are met, we look at the automatic UK tests. And if any of these tests are met, you're deemed to be automatically UK resident for the tax year. And then if the taxpayer doesn't meet any of the automatic tests, we use the sufficient ties test. And this looks at the connections or ties an individual has to the UK in conjunction with the number of days that they spend here in the year. And that was used to determine if they are going to be deemed UK resident or not. And typically an individual is deemed to be UK resident for a full tax year, or non-UK resident for a full tax year, and that runs from April to April. However, there are certain circumstances where you might qualify for split year treatment. And when an individual is relocating to the UK, so for example, moving from Hong Kong to the UK, that would mean that they would be deemed UK tax resident from the time that they actually relocate here, and it wouldn't be backdated to April. So an essential part of the planning that we do is to determine when an individual will actually acquire UK residency, as that will greatly impact their exposure to UK tax. Just go on to the next. Yeah. Another concept that's very important to UK tax is the concept of domicile. So broadly speaking, a person is domiciled in a jurisdiction in which they currently reside, which they have the greatest sort of connection, and where they intend to settle permanently. So for the majority of clients that we see coming over from different countries or Hong Kong to the UK, you'll acquire UK residency quite immediately, but they might remain non-UK domicile. And domicile is very important when you're determining an exposure to UK tax on overseas income. So where an individual is resident and domicile in the UK, they'll have to pay tax on their worldwide income and gains on an arising basis. But where an individual is resident but non-UK domicile, they're going to have the opportunity to claim the remittance basis of taxation. And that means that you're only taxed on your overseas income if you bring it to or use it in the UK. And there are some downsides, unfortunately, to claiming the remittance basis. Nothing's ever simple. So if an individual claims the remittance basis, they lose their entitlement to their tax-free personal allowance for income tax purposes. They'll also lose their annual exempt amount for capital gains tax purposes. And an individual might also have to pay a charge for claiming the remittance basis, and the value of the charge will depend on how many years they've been in the UK consecutively. And it's worth noting that if your client has been UK resident for 15 out of the previous 20 tax years, then they'll be considered deemed UK domicile, and then they'll lose the ability to claim the remittance basis at all. And when an individual is claiming the remittance basis and they bring funds to the UK tax charge will largely depend on the type of funds that they bring here. So this is what Ling was touching upon earlier. Foreign income that is brought to the UK is taxed at a maximum rate of 45%. Gains are taxed at a maximum rate of 28%. But clean capital, which includes any income and gains generated by the taxpayer before they became UK resident, can be brought to the UK tax-free. So we need to undertake careful planning to make sure that we identify the nature of the funds that are being brought to the UK. And I'd like to sort of give an example. So if, say, your client has one overseas bank account, any money in that account at the point that they become UK tax resident will be clean capital and can be brought to the UK tax-free. However, if that individual, once they become UK tax resident, starts to pay income and gains into that same bank account, they create what we call a mixed fund. And then subsequent remittances from that account to the UK will be taxed on a worse first basis, which means that it will be priority, it will be income, then it will be gains, and then it will be clean capital. And the effect of that is that it means that the individual can't access their clean capital tax-free funds until they've remitted all of the income and gains in that account. So the key planning for us, and something that we need to do really before an individual becomes UK tax resident, is to work with the offshore banks and set up separate accounts for each type of funds. And that means that they can then maximise the amount of clean capital that they bring to the UK without generating a UK tax charge. And then I'll pass back to Ling to talk about some other key aspects.
Thank you, Josie. Just a couple of more useful tax points for individuals looking to relocate to the UK then. As we mentioned before, if you brought foreign income and gains in the UK, there may be a tax charge on that. But there is a certain relief available to people who are entrepreneurs, and they are able to remit what would otherwise be taxable foreign income and gains. They are able to remit that for the purposes of investing in British trading businesses. There are complex rules to meet, but if this relief applies, it means that they can use funds which won't be taxed on the way in. And as long as they remove those funds after an exit, then there is no tax charge on the remittance overall. So that's quite a benefit to our clients who are quite more entrepreneurial focused. In terms of individuals who like to look at properties, we can consider a corporate structure for them, where they have quite a lot of high-end rental properties, where they're also looking to hold these for investment purposes as well. Holding a property in a corporate vehicle may be very tax efficient for them. There's a lower corporation tax rate on the income overall compared to individuals, and this can be quite beneficial. Well as an next strategy, but a picture can be very beneficial. In terms of individuals looking to come to UK, when they start thinking about being in the UK more longer term, we think about inheritance tax. For UK resident non-domiciled individuals, only their UK assets are subject to UK IHT, and their offshore assets are exempt. So in terms of tax planning, we can look at what assets they have overseas, consider whether an offshore vehicle such as a company or trust may be relevant, and use this to minimize their exposure to UK IHT. Now, where families settle in the UK, their children go to university, their children purchase properties, and they look like they're going to stay in the UK much longer term, there is a risk of acquiring a UK domicile, either acquiring the domicile itself or being in the UK for long enough. 16 consecutive years to become deemed domicile in the UK. Once you're deemed domicile in the UK, the IHT works a little bit differently. Instead of only being subject to your UK assets, your worldwide estates will then become subject to UK IHT. Ahead of this, we can do some tax planning to create what's known as an offshore excluded property trust. Any assets put into this trust, if qualifying, will be protected against UK IHT, even if the individuals in the family subsequently become domiciled in the UK. And that could be very beneficial for them. Just to let you know, inheritance tax is typically charged at the moment at 40%. Above the nil rate band, which is 325,000. So this can be a substantial tax saving. I'd like to finish off with a couple of case studies to really show you how this works in practice. So we got Mr. X. He came into the UK in 2019, and we were lucky enough to have met him virtually and spoken to him in advance of his relocation to do some tax planning. Looking at when Mr. X will arrive in the UK and looking at the number of days he will be in the UK, we found that he would actually be UK resident, not at the point of arriving in the UK, but at the subsequent April. So that gives us some time to implement any structures and any tax planning in advance of him being officially UK resident and officially subject to UK tax. We had a look at his worldwide affairs and worldwide income and found that the remittance basis was clearly more beneficial to him to claim this, and this would save him quite a lot of UK tax on his overseas income. And as I mentioned before, he became UK resident a little bit later than actually arriving to UK. So that gives us full opportunity to maximize the amount of clean capital he had and full opportunity to clearly segregate his offshore bank accounts and segregate his funds going forward. As Josie mentioned earlier, we want to maximize the clean capital, and we also want to minimize the risk of creating a mixed fund, because remitting anything from mixed fund would be on the worst case basis, where income would be matched first in tax, then gains before accessing the clean capital. And being able to segregate funds going forward in advance of him becoming UK resident by creating mirror accounts, we can minimize or eliminate the risk of mixed funds so that there's minimal tax burden on him bringing funds into UK. And he did buy a property in the UK and didn't have to pay any tax on remitting those funds. That was a really good result. On the reverse side, we're going to talk about Mr. Y. And Mr. Y is, I would say, also quite a typical client that we do meet. So Mr. Y first came into the UK in 2012. He wasn't that well aware of UK tax rules, and he had a local accountant who perhaps wasn't a specialist in dealing with foreign taxation and the remittance basis. And over the years, Mr. Y remitted a significant amount of funds to the UK to purchase residential property, investment properties, and also to fund his own lifestyle. So when we had a look at the situation, we found that Mr. Y was UK resident from 2012 onwards and has been UK resident every year. His accountant had filed his tax returns on the remittance basis correctly at the time, because Mr. Y has significant wealth overseas and has significant amounts of income and very little UK tax exposure. So the remittance basis was the right call. However, Mr. Y didn't quite realize that he couldn't just remit anything from overseas. And actually, after us having a closer look at the funds remitted, we matched out of 4 million, that 2 million of these funds were matched to income and gains. So some of that is taxable at 45%, the rest taxable at 20 or 28%. Now, the reason we were involved is because HMRC had already opened an inquiry, and we're asking Mr. Y to demonstrate why he had not declared these remittances. And it's a very costly matter to resolve the position, not just because there's quite a lot of tax to pay, but once HMRC are already investigating, it's really difficult to close the matter. And this is a very complicated affair and causes a lot of distress to clients in this position. So I think the take-home message here is that quite a lot of this is actually very much avoidable if the right pre-arrival tax planning was undertaken. And you can imagine that out of 2 million of chargeable remittances, that's a significant amount of tax to pay, which we could have reduced to a minimal amount or nil if we had the opportunity to advise him from him coming to UK and maximize his clean capital. In terms of key takeaways, well, relocating to the UK is a very attractive option for overseas clients. A lot of people from Hong Kong do like the UK because of the high quality of life, because of the education, and because of the quality of properties to purchase. And the UK, as you can see, is very tax efficient for overseas high net worth individuals. However, if you take anything away from this presentation, please take away the fact that pre-arrival tax planning really is essential. With the right tax planning, we can minimize UK tax liability on the year they come and going forward. And most importantly, we can minimize or get rid of the tax due on remitting funds to the UK. Thank you very much. I will hand over to Brandon now as well. Thank you.
Thank you, everyone. Thank you, Rahul. Thank you, Ling. Thank you, Josie, for your earlier presentation. My name is Brandon Meyer. I'm the founder and managing partner of Meyer Law Group, which is an U.S. immigration firm based in San Francisco. I'm going to talk about some of the high-level options that Hong Kong nationals have for possibly relocating to the United States, many of which track somewhat to the concepts that Rahul discussed earlier. So I'll start with the so-called EB5 program. EB5 is an investment program which requires an investor to invest at least $900,000 into a qualifying project that creates at least 10 jobs for US workers. Based upon that, the investor, one spouse, and children under the age of 21 are able to obtain US visas, permanent residence visas, to live, work, and study in the United States if they want to. Some people do set up their own EB5 businesses. However, most people find it very difficult. So 99% plus people who do EB5 do it through what's known as a regional center. All a regional center is a non-exclusive license granted by US Immigration for project developers to accept EB5 capital into their projects. Doesn't require, the good thing about EB5 is it doesn't have any management responsibilities. It's just a pure passive investment program. Overall, it's a three-step process. The investor and their family receive conditional green cards after step 2. Now, for Hong Kong nationals, if we were having this conversation last year, I would say it would be roughly a 2 to 2.5 year process from start to when the investor and their family can move to the United States as permanent residents. However, that has changed, and I'll discuss those changes, which are unfortunately negative, later on during my discussion. So just some of the highlights of EB5. Unlike some of the other programs, I said the person who made the money does not need to be the principal applicant. So what that means is that the funds can be received via gift. Now there is the clean capital concept with EB5 as well. The big test of EB5 at the beginning is the investor has to show that however they obtain the money, either through a gift from a spouse or a parent or a friend, or through their own work and investment, that source of capital is lawful, is clean, and that's what's being used to make the investment. Now, the US government, when they give out green cards to people, they're doing so on the basis that people actually intend to live in the United States. Now, some countries out there, China and Vietnam, for instance, people go through EB5 for one of two purposes. One, they want to have the green card in case they need to, need a bolt hole, need somewhere to go very, very quickly. And some of them do it purely for status. It's a status symbol. I have a US green card. They actually have no intention of coming to the US, and that's fine. But at the beginning, if that's someone's intention and it's really for the family or children, we want to discuss that, because it doesn't make any sense for someone to go through this process if they actually don't have an intention of living in the United States, especially since you go down to point number 5, that if by obtaining a US green card, then it subjects the investor to taxation on worldwide income. And that's why, just like with going to the UK, you should discuss, pre-tax immigration planning with someone such as the experts at Grant Thornton. The US government does take this very seriously, and so they will expect investors who to file US tax returns every year after moving to the United States. Assuming residency, tax, and other requirements are met, the investor and their family may be eligible to apply for US citizenship after roughly 5 years. But there's no obligation to do so. You can remain permanent residents for the rest of your life if you wish, without obtaining US citizenship. So because of some of the recent changes to how Hong Kong will be treated under US immigration and nationality law, the so-called L1A temporary work visa has become more of a discussion point. Now, L1A tracks to UK tier 2 visa. So it's designed for companies overseas, and this is an important point because this is an important point that's being lost in the way that L1 is being presented, or shall I say marketed to people in Hong Kong. It's for companies to transfer managerial and executive personnel from an overseas company to the United States. So a good example of that would be Grant Thornton, for example. So if Grant Thornton wanted to transfer either Ling or Josie to the United States, if they were managerial level, Grant Thornton would transfer both of them to the US and using the L1As. However, this is also a visa that's good for entrepreneurs as well. Now, but this requires a company overseas in either Hong Kong or China. So it has to be at least 50% overlapping ownership between the overseas company and the US company. And the transferee has to work for the overseas company for at least 1 year in the 3 years prior to transfer in a managerial or executive category. Now, this is important because when, for mainland China, when EB5 was very, very popular, then because it was oversubscribed, the waiting periods became 10 to 12 years, people started shifting to L1A. And we'll probably start to see the same dynamic with Hong Kong as well. So for most people, L1A maximum period of 7 years. Now, the process can be pretty quick, up to 15 days if you choose expedited processing. Children can come to the United States under 21, study in either public or private schools, depending on their choice. There is a green card or permanent residence option, usually after at least 1 year or more of being in L1A status. But one of the things that we need to talk about is that people see L1A as a cheaper and easier option than EB5. If it's done right, it's not cheaper. I mean, yes, maybe if someone's starting a business from scratch, maybe they can get away with a $250,000 to $300,000 initial investment. But in order to do it properly, it's probably going to end up being at or above the $900,000 minimum investment level for EB5. So the typical failures we would see would be, for an investor, so, okay, well, I'm going to buy a franchise, a pizza franchise, for example, but I don't have any intention of actually, running this pizza franchise. I just want to send my wife and my children to the United States so they can study. So investor gets the L1A, he owns a pizza franchise, hypothetically in Irvine, California, takes the wife and kid, leaves them there, goes back to China, Hong Kong, or wherever. Literally no one's minding the store. A year later, once they go to renew the L1A, they don't meet the standards. The business didn't grow to the way that it was projected. The employee count that was projected wasn't met. Revenue and profitability wasn't met as well. Denied, extensions denied, everyone has to leave the US. So L1A, long story short, L1A is a great option, but anyone who's looking at it as a quicker, cheaper, and easier option than EB5 needs to really look at it differently, that this is really designed for those who are intent on developing a serious business in the United States. So Hong Kong. So as I mentioned earlier, if we were having this discussion 12 months ago, Hong Kong was treated favorably under US immigration law. Unfortunately, that has changed now that the US government has deemed Hong Kong to, quote, be no longer sufficiently autonomous from the People's Republic of China. So what that means is that we think, there hasn't been 100% confirmation, but what we think is going to happen is that Hong Kong nationals, those who are born in Hong Kong, will be treated exactly the same as those born in mainland China. So what that means is that there's substantial backlogs for green cards or permanent residents in all the major employment-based and family-based immigration categories in the US that currently Hong Kong nationals are not subject to, but will be if Hong Kong is treated just like the mainland China going forward. So what that means, for instance, is so if it took 2.5 years for someone to come to the US in EB5, it may now take them 10 to 12 years. So definitely not a good development. Things could change. The US Congress could intervene. There could be litigation on these points. But this is something that we need to look at for people planning to relocate to the United States. That's on the green card side. Will be some different treatment on the L1 and other non-immigrant work visa side as well, but very, very minor. The big problem will be for those from Hong Kong who are seeking permanent residence. Oddly enough, this does not apply to Macau. Macau will still be considered separate and sufficiently autonomous for US immigration purposes going forward. Now, I have something in here called the E2 treaty investor option. This is not currently available to Hong Kong nationals yet, but going forward, if those who move to the United Kingdom and obtain full UK passports in the future have the separate visa option available called the E2 treaty investor visa. Some of it overlaps with the L1, but it's actually quite favorable. With the E2, there's no overseas company requirement, and there's no prior overseas work requirement as well. So the E2 can be used as an entrepreneur visa, as a startup visa, in ways that the L1A cannot be. Now, once individuals from Hong Kong obtain UK passports and become eligible for E2, it gives those who apply and qualify work E2 visa for up to 5 years, renewable indefinitely as long as the business is operational and still meeting reasonable revenue and employment requirements. Now I have here number 3 that there's no minimum investment that is required for an E2. That is legally correct. However, the US Embassy in London receives more E2 visa applications than any other US consular post anywhere in the world. So they've developed their own standard where we advise clients that the London Embassy will really only treat applicants who invest $250,000 or more seriously. So anything that's less than $250,000 is likely to encounter resistance from the US Embassy in London. And so that's all I had. So now I'll turn it over to a Q&A, and here is our contact information for those of you who wish to reach out to either Rahul, myself, or Ling. So with that, I guess now we'll open up the questions. You're on mute, Rahul.
Thank you, Ling, and thank you, Josie, for your very informative presentations. We've got some questions online. I think Ling is going to answer Jimmy. So over to you, Ling.
Okay, thank you. So Jimmy asked, when does one consider as tax residence? So that seems like a really simple question, but it's quite complicated. It really depends on the situation. So if you recall earlier when Josie was talking about the statutory residence test, there's quite a few different tests in there. And broadly speaking, there's 3 main tests. There's an automatic overseas, automatic UK, and a sufficient ties test. So to give you a few examples, in the automatic overseas test, If you've spent less than 16 days in the UK in the tax year, so from 6th of April to the following 5th of April, if you've had less than 16 days, and the day for this purpose is actually at midnight, so it means if you arrive in the day and you leave before midnight, technically for the test purposes, you haven't been in the UK for a day. So if you spent less than 16 midnights, then you're not UK resident. If you're working full-time overseas, then you're not UK resident in the tax year. And those are the main parts of the overseas test. The automatic UK tests, broadly speaking, if you're in the UK for more than 183 midnights, then you will be UK resident for that tax year. Anything less, it depends. If you're working full-time in the UK, you can be deemed to be UK resident. If those tests don't really apply to an individual circumstances, we then look at the sufficient ties test. And then it really depends on how many ties they have to the UK. The ties overall are a family tie, so whether you have a spouse or you have minor children who are residing in the UK, whether you have available accommodation to you in the UK, whether you have a work tie. And the work tie for the ties test is that if you work for more than 3 hours a day for at least 40 days in the full year, whether you've been in the UK more than 90 days in the prior year or the year before, and whether you've been in the UK more than any other midnights compared to any other country. So this is particularly important for the very internationally mobile clients who may spend some time in the UK, some time in the States, spend some time on their yacht, etc. The more ties you have to the UK, the lower number of days you can be in the UK before becoming a UK resident. And typically that could be as an arriver, so someone coming to the UK from Hong Kong, that could be as little as 45 days, or that could be as many as 182 days in terms of days in the UK before becoming UK resident. I hope that answers your question, Jimmy.
Thank you, Ling. Are there any more questions from anyone else? You could either type your questions in the chat box, or you could just unmute yourself and speak, and we can answer them for you. So if none of you've got questions, we could end the presentation here. Thank you everyone for joining. Have a good rest of the day, and you can email any one of us directly if you've got any more questions, and we'll be in touch soon. Thank you.
Thank you.
Thanks, everyone. Thanks.
Thanks, everyone. Have a great day.